Hello, my name is David Maddison, and I'm a barrister at Cobden House James in Manchester. I want to talk to you today about the geographical and cultural considerations that have to be borne in mind when dealing with female genital mutilation protection orders. Firstly, I want to look at what FGM is and, importantly, what it is not, before moving on to look at the geographical spread of the practice. I'm then going to discuss the cultural and social implications that have to be considered before looking at the case law and how I help to change the law. Finally, I want to conclude with some hopefully helpful pointers to assist you if you're dealing with an application for an FGM protection order. First of all, obviously, it is necessary to discuss what FGM is. And what it is actually defined by the World Health Organization. There are four types, one which is a group of three, and then there is a fourth type that stands alone. The first three are ranked in terms of increasing invasiveness. The first being clitoridectomy, group two is excision, group three is infibulation. Group four is more of a catch-all group that describes and encompasses other practices such as piercing and pricking. If you're dealing with a case that involves or you believe involves FGM, it is important that you get it diagnosed and described by an FGM trained paediatrician. You may need to obviously speak to a paediatric hospital or your sexual assault referral centre, but it is very important that they are FGM trained. I've spoken with the St Mary's Sexual Assault Referral Centre in Greater Manchester. Unfortunately, they say that they do have FGM trained paediatricians who would be able to assist in these cases. So having described then what FGM is, it's important to discuss what FGM is not. And the most important thing to say what it is not Islamic. It has no basis in Islamic religion. And this can be proved by the simple fact that the practice of FGM predates the founding of Islam. It is, though, has to be recognised that many of the groups who practice FGM are also Islamic, but it is important when you consider that fact that you recognise that it is a cultural practice and it is not one that is rooted in the religion. Another thing to recognise is that FGM is not analogous to male circumcision. The effects of FGM are debilitating. They can affect reproduction, and to a significant extent, they are about exercising control. So let's look at the geography of female genital mutilation. And the first thing I put up is this standard Mercator projection of the world. It is what we recognise as the map of the world. However, what you need to understand is it is incredibly misleading. For starters, it suggests that Greenland is the same size as Africa, and quite clearly it is not. What I want to go on to look at is explain the geography, not only the geography, but how important culture and particularly ethnic grouping is when you are considering cases involving FGM. What I have next is the map that blows my mind every time I see it. This is the real size of Africa with countries in the world overlaid at their real size. And what you might see there is there are countries we think of as massive: India, China, America, and they are easily engulfed within Africa. I've put this here to help people recognise just how vast Africa is. And to speak of people as African really misses any kind of nuance that needs to be brought to these cases. You will see this is a continent that can encompass, as I say, China, India, the United States, which is essentially the same size as the Sahara Desert alone. It encompasses Eastern Europe and a good portion of Western Europe as well. The important thing to recognise is that Africa is huge, and therefore it is too big to think of FGM as being an African cultural practice. What we generally understand Africa to look like is this, and it is a perfectly valid map. But all it does, though, is define countries and then, therefore, people's nationalities. But if you look at it, say, particularly in the northwest, you'll see the very neat borders between Algeria, Mali, and Niger. But it is obvious that there is no natural border that forms such a very elegant and simple Y shape. And that is because these borders are largely imperial and entirely arbitrary. What they don't reflect is the ethnic grouping which people might identify themselves with. So whilst this is a familiar map and a perfectly valid map, this also is an entirely valid map of Africa. And what this sets out is the ethnic diversity within Africa. This is a very important concept to understand when appreciating FGM and Africa. There was a study in 2009 that found that, in fact, Africa has greater ethnic diversity within its borders than the rest of the world put together. It is incredibly ethnically diverse, and because of that, it's perhaps very difficult to put into a European context. The best analogies, although I think and I accept they're fairly flimsy, are perhaps areas such as the Catalan region and the Basque region, where particularly, for instance, the Basque region, it flows over borders, it has its own language, it has its own distinct cultural identity, but it comes nowhere near close to describing the ethnic diversity you get in Africa itself. So let's take one small example. Nigeria. That is a map of Nigeria. And what you can see in the thick black line is what you would see on the Mercator projection of Africa. That is its recognized national boundary. But what it also shows is the important ethnic diversity. You may see some names there that you may be familiar with. You may see Yoruba, you may say Igbo. But it's important to recognize that these ethnicities don't respect national borders, that they cross national borders. And these ethnicities carry with them their own particular culture. Nigeria has a population of 195 million people. So to describe someone in Nigerian alone really offers no nuance and doesn't bring the necessary nuance that is required to properly understand the risk of female genital mutilation. What we need to look at is these individual ethnic groups and what is their practice and their attitudes towards FGM. There are many useful resources to do this on the internet, and I would point you first perhaps to the National FGM Centre, or the UK National FGM Centre, and they have one particularly useful resource, which is this interactive map, which I've taken a screenshot of. You can see the URL address at the top, but it's nationalfgmcentre.org.uk. There are some important and useful things to pick out from this map, but perhaps the first thing to point out is that it's not just Africa. FGM is not just an African practice. It happens, it seems, on pretty much all the continents in the world. But I would thoroughly recommend this particular website as a resource of information. What the interactive map allows you to do is to focus in on countries, and it starts to give you that real detail that is needed to describe what the risk of FGM might be to any particular person. So to continue with Nigeria, what we see rather than the simple maps we've been produced, it is much better information. You'll see there that 18.4% of women have suffered female genital mutilation. That is about 20 million women and girls. What also it describes, and you'll see at the bottom, is who the practicing groups are, which are the ethnic groups that have a cultural system that involves female genital mutilation or can involve female genital mutilation. It also, for instance, points out regional information that FGM is perhaps highest practiced in the southwest of Nigeria. What this map, though, is very useful to do, though, is to challenge you to think of other places in the world where you might not immediately think as practicing FGM. So we turn to Egypt. Egypt, you'll see there, actually has a prevalence of 87% of women over the age of 15 have suffered female genital mutilation. Because of its population of about 100 million, Egypt actually has the highest number in absolute terms of victims of FGM, where it is not necessarily a country you might immediately first think of where there could be a risk of female genital mutilation. It also forces you, this map, to look at other regions that you might not immediately think of in the world, such as Russia. Obviously, Russia doesn't have a significant practice of FGM, but what this map is very good at is it highlights that there are some districts, and there are some districts in the Republic of Dagestan and other districts where the prevalence of FGM can hit 50%. And what it comments in terms of practicing groups is that it mentions that it is among Muslim communities. Although again, one has to stress that it is a cultural rather than religious practice, it is coincidental that that the people are Muslim, and it doesn't stem out of their religious beliefs. Other information about the prevalence of FGM can obviously be found on the internet. There is information regarding UNICEF, or from UNICEF and the World Health Organization, although they may not be as useful as perhaps some of the information from particularly the Home Office, which I have to say has produced some very useful information and guidance in these cases. The NHS also collates statistics in relation to female genital mutilation. Obviously, it rarely comes across cases where it has occurred and has been recent. What it actually generally collects information on is where frequently women, rather than girls, go in for obstetric or gynecological appointments, and it will record if they have suffered female genital mutilation. These are published quarterly, and the last quarter that was produced before lockdown happened was produced at the end of February 2020. And that noted that in Greater Manchester, there were 135 cases or new patients recorded with FGM in just 90 days. So that means that every day, the NHS in Greater Manchester comes across one or two new patients with FGM. And that, I think, really does underline how prevalent it can be, and something that we need to guard against, even when we are here in Greater Manchester. There are other resources which I can thoroughly recommend. These are two studies published by an organisation called AFRUCA. They are based in Greater Manchester, but what they are very useful for, and if you're watching this elsewhere, is that they provide narrative studies of FGM. They were done largely through focus groups, but what is very useful about it is that it isn't just focusing on victims or even women. It gets to people together, men and women from various cultures who practice FGM, and it records what their views are. So it is a very worthwhile read to get a good cultural context as to how FGM is perceived within the various ethnic groupings that do it. So, having avoided talking about the law for as long as possible, I now have to turn to the law. The law in relation to female genital mutilation in the United Kingdom is governed by the FGM Act 2003, and there are two parts to it. The main act obviously establishes the criminal offence of female genital mutilation. It also, for practitioners, importantly creates reporting duties. The other part that is important is Schedule 2, and that makes provision for the making of female genital mutilation protection orders. This is one of those cases alongside forced marriage protection orders, whereby there were tools available to judges previously, but none of them were quite the right fit for the task in hand. And as a consequence, FGM protection orders and forced marriage protection orders were created to create a proper tool to meet the problem that we have to deal with. So in terms of the main parts of the Act, FGM, it established obviously, is a criminal act. Whilst it refers to girls, there is in fact no age limit in relation to when someone may apply for a female genital mutilation protection order. Another important and unusual aspect of the Act is that it is the extraterritoriality of the Act. That means that a person is guilty, or a UK citizen can be guilty of FGM even when they are abroad, and even where it is they aid or abet or commit FGM, where in a country where FGM is not an offence. So it is one of those unusual cases where the United Kingdom courts reach into other countries, and the law follows the United Kingdom citizen wherever they might be in the world. It also creates reporting duties at Section 5B, and it talks there about registered healthcare professionals. Obviously, there are certain professionals who it would be obvious to consider, such as doctors, nurses, etc. But it is important for lawyers to recognise that other healthcare professionals fall into that grouping, including social workers and children's guardians. So if you're acting for a guardian and there is a case where FGM is involved, your client has a duty to report that. They have a duty to report FGM when it has been carried out. or where they see signs that FGM has happened. There are, however, certain parameters where the reporting duty does not bite, and that can include where they simply suspect it's happened or they suspect there's a risk, and also when the person that may have suffered it is in fact over 18. Schedule 2 deals with forced female genital mutilation protection orders. These are, like I say, a relatively new tool for judges to protect against FGM. And they are given to protect the person who is at risk of FGM. Local authorities, or as it is described in the Act, designated third parties can apply for them. No other organisations actually been designated yet other than local authorities. But that's not necessarily an issue, because any other person, for instance, teachers, police, charities, etc., can apply in any event with the permission of the court. The application is made to the High Court or the Family Court, and there is no fee. What can a court do then if it is asked to make a female genital mutilation protection order? Well, Schedule 2, Section 1 sets out what is an incredibly broad discretion. It looks as a court can do almost what it wants. It can order such prohibitions, restrictions, or requirements as it wants, and any other terms as it considers appropriate for the purposes of the order. So, that is a seemingly almost infinite discretion. However, it is not infinite. The power is not limitless, and this is largely governed by an important distinction between Article 8 rights, which is obviously the right to family life, which as family lawyers we're very, very familiar with, and Article 3, which is the prohibition against torture, inhuman or degrading treatment. It's very important to understand when you're looking and dealing with forced FGM cases to get the tension between these two. And it's best summarised by Mr. Justice Hayden in the M&N case in 2018. Article 8, as we know, and are probably quite familiar with, governs the right to family life. And the state's obligation there is not to interfere with family life unless it is necessary to do so. That contrasts sharply with Article 3, where there is a positive obligation on the state to protect a citizen against torture, inhuman or degrading treatment. So obviously, and the tension at the heart of FGM protection orders is the desire to protect the person from inhuman or degrading treatment, but also respecting their right to family life, and that the courts and therefore the state should not interfere with that family life. This is a very important concept to get to grips with if you're dealing with an FGM case. There are examples as well in the case law of limitations. Re-X is a case where a broadly drawn worldwide travel ban was struck down by the Court of Appeal. And the reason it was struck down is because it was too broad. At a rehearing, though, a nearly identical ban was found necessary. But what the rehearing did is it broke down that more broad ban into individual specific prohibitions. And what you must do when you are considering applying for an FGM protection order is consider each prohibition you want and be able to justify it and explain exactly why any particular prohibition is needed. It is not sufficient simply to say that this child shall not leave or not go to this country. Also, there are examples where an FGM protection order can't be used as a backdoor to a non-molestation order. You may recall when I set out who can apply for an FGM order, it is there, an FGM protection order is there to protect the person at risk. It can't be used as a way to obtain a non-molestation order. However, in that case, an order that prevented a parent coming within 100 meters of the child's school was acceptable, because although the mother would benefit from it while she was attending at the school, the essence and the purpose of the prohibition was actually to protect the child. Another important limitation to recognise comes in relation to asylum. What the family court must do is not overreach into other jurisdictions. it is important that we recognise that there are separate and distinct jurisdictions, particularly exercised by the Immigration Tribunal. Therefore, the family jurisdiction can't injunct the Home Secretary not to deport someone. It can try and influence the decision, but it's important that the family court recognises that ultimately asylum decisions are matters for the Immigration Tribunal and the Immigration Tribunal alone. This can create certain conflicts, particularly with the concept of the extraterritoriality that falls within the Act. This is because a person, whilst they are in the United Kingdom, obviously it is subject to that law. But if there is a concern that, for instance, the daughter in a particular family is at risk, if they are then deported, they are deported to another country, but they would not be a UK citizen either. Therefore, the law would not travel with them, as I described it earlier. The extraterritoriality would not attach to them because they are no longer a UK citizen abroad. Lord Justice Moylan in Re Ex helpfully set out what the broad considerations are that the court should consider in making a female genital mutilation protection order. And there are three basic factors. Firstly, there needs to be at least a real risk of FGM. The court needs to consider what are the protective factors. And finally, the court needs to consider what is the interference in family life. This has been broken down into what have been described as, or I describe as, macro considerations and micro considerations. Macro considerations are the broader thematic considerations that might surround a case that concern the cultural and ethnic context within which the case occurs. And that's why I've tried to set out earlier the importance of not just geography, but ethnicity and culture within considering female genital mutilation. So things such as what is the prevalence of FGM nationally, and you'll notice what is the prevalence of it regionally is considered. What are the societal expectations? Does that particular ethnic group expect a girl to have or go through female genital mutilation? What age are girls cut? Because that could inform the risk. Some ethnic groupings cut earlier, some ethnic groupings wait until they're teenagers. And you may need to consider that in the context of any particular girl you consider is at risk of FGM. A lot of these macro considerations can be answered by considering or consulting the interactive map and the resources at the National FGM Centre and also provided by the Home Office. There are also micro considerations, and these are the considerations that fall within the family. These are things like, is there a history of FGM within a child's wider family? What are the family attitudes towards FGM? I did a case where the court didn't make an FGM protection order because it was satisfied that whilst the father's family practiced FGM and there was a history of FGM within his family, the mother's didn't. She wasn't in an ethnic group that subscribed to FGM. She herself hadn't been a victim of it either. And also she had taken protective steps to ensure that there was no risk of the father meeting or being able to contact the girl. So therefore, an FGM protection order was not necessary in those circumstances because the practical and cultural context pointed towards respecting the family's Article 8 rights to family life. One has to consider as well FGM in the context of the threshold. And by that, obviously, I mean the threshold for the making of care orders and interim care orders. Mr. Justice Mumby considered this in the case of Re B and G, and he came out with what could have been controversial comments. Firstly, he said any form of FGM constitutes significant harm. Now, that may be self-proving, but what he went on to say is that in his view, FGM type 4, that catch-all group that I considered, must also amount to significant harm. But he said, if it does, then in his judgment, the same must be said of male circumcision. Now, potentially that opens a whole can of worms because, as I said at the start, it creates potentially a theoretical analogy between male circumcision and female genital mutilation. Fortunately, he put the lid straight back on that can of worms because what he rightly pointed out is the often overlooked second limb of the threshold test, We are very familiar with the idea of a child being at risk or having suffered or being at risk of suffering significant harm. But he emphasised the fact that there is a second limb to it, which is considers whether the care is that of the standard that a reasonable parent might do. And his view was that there is no way that a reasonable parent could ever permit or allow or suffer FGM to be performed on their child, whereas the same cannot be said of male circumcision. So whilst he has made a very clear statement that FGM of any type amounts to significant harm, what he has drawn a line between, and properly drawn a line between, is between female genital mutilation and male circumcision on the basis of reasonable parenting. I now turn to the Children Act 1989 Amendment Female Genital Mutilation Act 2019. And if you may forgive me for inserting myself into the narrative in this, this is an act that I managed to get through Parliament after doing a number of these cases and recognising that there was a gap in the protection that girls at risk of FGM faced. The origin of the act was that I was doing a case with a judge who was so concerned about the risk of FGM that she wanted to make an interim care order. So we went to section 8.4 of the Children Act, but unfortunately found that in fact FGM proceedings did not fall within the definition of family proceedings. So the judge was not able to make an interim care order. I consider this to be absurd, particularly when you consider the other types of cases that can fall within that fall within section 8.4. The best example being that a girl at risk of forced marriage could be protected by an interim care order, but a girl at risk of female genital mutilation was not. Therefore, I took it on myself and managed to enlist the help of Lord Berkeley of Knighton. And over 2.5 years, we managed to get this act through, which amends the Children Act 1989 and now includes female genital mutilation protection orders as family proceedings. And therefore, judges can now make interim care orders in these cases. Another thing that crossed my mind, though, and this feeds in from the comments I've just outlined from Justice Mumby, is if all types of FGM are in fact significant harm, does it follow that an ICO it must also follow? I would say no, obviously. An interim care order cannot be self-proving. It has to be proved on the facts. But what I do think, and I do venture to suggest, is that when a court makes a female genital mutilation protection order, it is acknowledging that there is a risk of significant harm. What I think courts should do in those circumstances is, in fact, effectively do a cross-check to consider, yes, there is a risk and an FGM protection order is necessary, but do a cross-check to consider whether an interim care order is necessary. One should not follow the other as night follows day, but I think there is room for certainly courts considering one when making an FGM protection order. There are examples as well of protection orders being refused. One example in 2017 is re-CE. And there, the judge found that, in fact, the allegations made by the mother of risk of FGM were entirely a sham for immigration purposes. And the interesting footnote to that case is that, in fact, the outcome of the case is that the father was allowed to remove the children to Nigeria. This is because he was able to prove that whilst he was from the Igbo region, he in fact was from an ethnic grouping called Delta Igbo. And whilst, and you may recall me mentioning it when I looked at the interactive map, that the Igbo ethnic group do practice FGM, the Delta Igbo do not. And therefore, because of that level, like that granular level of information and facts that will be able to be put before the court, the judge was satisfied that, in fact, it would be safe to allow the father to emigrate to Nigeria, and there would be no risk of the children suffering FGM. So, really, to sum up, here are some practical tips when considering applying for an FGM protection order. It is important to go into a very granular level of detail. It is not enough to simply talk about the country or perhaps even the region that a person is from. It is important to put this family in their cultural context, because it may be that they are have a cultural background that has no history of FGM. and therefore the risk would be mitigated. It's important also to look within the family for evidence. Has another female relative suffered it? Has the mother or the grandmother or aunts, etc., have they suffered FGM? It's important also to come armed, I think, to court with empirical evidence. What is the country you're talking about? What is the overall risk there? What is the risk to girls of the age of the child that you might be dealing with? These, again, can all be helpfully obtained from the National FGM Centre website, the World Health Organization, UNICEF, and the Home Office. And the other important thing as lawyers to do is to analyse each facet of the order that you're seeking and be able to justify it. Because you will have to, and the court should properly challenge you as to the tension between Article 3, which obviously you're seeking the protection from suffering inhuman or degrading treatment, versus not just the family, but that particular girl's right to a family life. You need to be able to address that and demonstrate why each aspect of the order you seek is necessary. So thank you for your time. I hope I've offered you some useful information. I hope I've pointed you in the direction of useful sources of information, and hopefully given you some advice as to what to do if you're seeking, or indeed if you're responding to an FGM protection order. My name is David Maddison. I'm at Cobden House Chambers, and if you wish to discuss any of this, I'd be more than happy for you to contact me through Chambers. Thank you.